Everything cool, Rasta. Everything cool. All on my leg. It's like, is that serious? Later, Robert.
Hi, folks. Just give Ms. Archer. She will be in about 10, 15 minutes, please, okay? Can anyone hear me?
Yes, sir. Yes, sir. All right.
All right, yes, give it 10, 15 minutes. She'll be there, okay? Thanks.
Good afternoon, everyone. Apologies for my tardiness. I got caught in the rain. How's everyone?
Good, thanks. Good afternoon.
Okay.
Good afternoon.
All right. So we have 1, 2, 3 persons on. How many are in the class? Oh, I might as well start, right? Because they can hear the recording. So we're going to begin with module 5. And I think you have it already. Mr. Pratt would have sent it out. So we'll start tonight with the Bohemian legal system. Is this a new topic to anyone?
Yes.
It is?
Yes.
Okay,
Yes,
so
it
that's
is.
Claudia. Keva and Rodrigo is new to you too?
No, ma'am, not quite so new. No.
Okay, all right, okay. So I'll go a little slow for the other ones, not too fast, and I don't want you to fall asleep. So you could always chime in. Okay, so in this segment, we're gonna look at the Bohemian legal system. And you always start by defining what is a legal system. And we know that it's really just the legal rules and the whole machinery that operate within a jurisdiction to regulate relationships. And those relationships can be persons, they can be companies, and the state itself. So you'll notice that when there are criminal matters, there's normally the person against the state or the state versus the person. If it's between 2 persons, you'll see one person suing another person. Or it could be where a person sues a company, like in employment law. Or you could have where a person decides to sue a government agency, or vice versa. So the first thing you have to know about law is there are 3 primary types of law. There's civil law, criminal law, public law. And under each one of those headings, there are subheadings. So civil law, you can have contract law, which is an agreement between one or more parties. You could have tort, which is an individual suing another individual for, it could be for personal nuisance, or where they are infringing on their private space. And then you could also have personal injury that falls under civil. Criminal law, I know you are aware of, that's murder, armed robbery. And then you have public law. And public law deals with administrative law, such as where you would go to a ministry in order to get an approval. And then you have constitutional law. And everybody know the constitutional law is the law that governs all of our behavior in the Bahamas. So there are sources of Bohemian law. And as you know, we were a former colony. So as a former colony, we have common law, and that common law, of course, is where we get our English common law. So as a country, we have English common law, which we follow because we are part of the Commonwealth of Nations. We have our Constitution. We have our Bohemian case law. We have Bohemian legislation and statute. We have our primary legislation, subsidiary, which is all our regulations. You have customs, which is how we actually interact with each other, how we conduct business. And then you have equity, and equity means fairness. So our sources of law is a combination of the 8 of these different components. And that's how our law operates in the Bahamas. So the Bahamian legal system is based primarily on English common law. So that means that as a former colony, we follow rules and principles that have developed from judges. And you'll see when we go down, we look at the structure of our court system, then you'll see what that means when we say we follow a set of legal rules and principles. So did anyone get a chance to read this module? Anyone? Kermit, did you have a chance to read it?
Sorry, Ms. Archer, I was having issues with my connection. But no, I didn't. I heard you asked if I read it. I didn't get a chance to read it.
Okay, all right.
I
Okay,
please.
Started it.
part of it. Okay, all right then.
Yeah, I'm halfway
So,
through as well.
okay, all right. So I start off now talking about the history of the courts in the Bahamas. I won't go into too much detail because like I said, we are a former colony, so you can read that on your own. So what we did is we went all the way back as to when we would have first started with our courts coming from the English court system. And you know that in the Bahamas, there are three branches of government: the executive, the legislative, and then the judicial branch. And then the head of the executive is, of course, the Queen, who is our head of state. And the Governor General represents the Queen. Our courts are the Supreme Court and the Court of Appeal, and both of those are established under the articles in the Constitution. So if we go back to our legal system, which was based on English common law, once the government of the Bahamas was formally constituted, as with any other colonial territory, the courts were gradually set up. And over time in England, those courts merged. Some merged, some fell away. And you ended up with the High Court of Justice, and it was divided into 5 divisions: the Chancery, the Queen's Bench, the Common Pleas, Exchequer, Probate, Divorce, and Admiralty. And then the 5 divisions were merged even further into the Chancery, the Queen's Bench, Probate, Divorce, and Admiralty. So in the Bahamas, our court structure, starting from the bottom, begins with the Magistrates Court. And that's the primary court for civil and criminal matters. The magistrates are appointed by the Governor General in accordance with the JLSC, the Judicial Legal Service Commission. And the court is presided over by circuit magistrates. And that includes a chief magistrate and 2 deputy chief magistrates. And of course, you know that the magistrate from New Providence, they go on circuit to other islands where there are no magistrates. So there are 17 magistrate courts in the Bahamas, 14 in New Providence, 2 in Freeport, 1 in Grand Bahama. And then you have magistrates who go to the family islands. The Governor General, acting on the advice of the JLSC, appoints the chief magistrates and 2 deputy chief magistrates. The Supreme Court is the next step up from the Magistrate Court. And that court is constituted pursuant to the Supreme Court Act. And it came into operation.
Question,
Go
are you
ahead.
reading from a particular page or you?
My page is, yeah, that should be page 5. You found it? You found it, right?
Yes, sir.
Okay, Supreme Court, right. So the appeals from the same Supreme Court can proceed to the Court of Appeal or to the Privy Council. So, you know, after the Supreme Court, there is the Court of Appeal, and after the Court of Appeal, the highest court of the land is the Privy Council. So in the Supreme Court, they have 12 justices, and that includes the Chief Justice. Supreme Court has unlimited jurisdiction in general civil and criminal matters. There are 2 judges assigned in Freeport, and matters from Freeport includes Bimini, Abaco, and Grand Bahama, and they are heard unless they are transferred to New Providence for a good reason. Then above, you have the Magistrate Supreme Court, you have the Court of Appeal. The Court of Appeal is the highest court that's resident in the Bahamas. And it's also established under the Constitution, Article 98. And the Court of Appeal sits on a full-time basis throughout the year. It has jurisdiction in criminal, constitutional, and civil matters. And it also includes appeals from the Industrial Relations Tribunal. Under the Constitution, the Court of Appeal Act, and other statutes. So if you look at the list I have here of 8 different things, you would see that at the Court of Appeal, they enforce the fundamental rights and freedoms of the citizens of the Bahamas. subject to Section 11 of the Court of Appeal Act from any judgment or order given or made in civil proceedings. Any person convicted on information in the Supreme Court, matters that come from the industrial tribunal, like I said before, they can hear matters on court martial, any offenses from the Proceeds of Crime Act, any disciplinary tribunal of the Bar Council, and also from the Medical Council and Disciplinary Committee. The registrar is the Civil Service Administrative Head of Department for the purposes of the Judicial and Legal Service Commission regulations, as well as the Public Service Commission regulations, and the accounting officer for the purposes of the Financial Administration and Audit Act. So the registrar also has judicial functions. Any correspondence intended to reach the justices of appeal or an individual justice of appeal has to be addressed to the registrar. And all official correspondence emanating from the court should be signed on behalf of the registrar of the court. So the Court of Appeal is comprised of a president, the Chief Justice, who's ex officio, who sits only at the invitation of the president, and such a number of other justices as may be prescribed by Parliament. So right now the number is 6, and that includes the president. So there are 3 resident justices of appeal and 1 non-resident justice of appeal. And then I've put their names here in a little box. And you know that's the Honorable Sir Michael Barnett, sitting justice, and of course, Justice Isaacs, Madam Justice Crane Scott, Justice Roy Jones, Justice Milton Evans, and Madam Justice Carlita Bethel. The constitutional age of retirement for justice is 68. The Justice of Appeal time can be extended. That is, he can be permitted to continue in office until he has reached the age of 70. So that's an extension of 2 years, or for such period after attaining that age as may be necessary for him to deliver judgment. Any questions? No?
So far, so good.
So
So
Ms.
far, so
Archer,
good.
that's specifically regarding appeals justices, or
Yes,
for all?
that's for the appeal justice.
Okay.
So after that, I give you a little copy of the structure. And let me go down to the next page, because I don't know, this computer now decided it wants to freeze. Okay. So you have the Magistrate Court, Supreme Court, the Court of Appeal, and then you have the Privy Council. And the Privy Council is established in the Constitution under Article 105.
So where's the Chief Justice in this?
The Chief Justice,
Yeah.
not at the Privy Council level.
No, I mean, and I was talking about this this diagram over with Honorable Michael Barnett and the Justices of Appeal. Or is this a separate thing?
Okay,
I thought
hold
the Chief
on.
Justice.
What you looking at?
JHA, the diagram.
Okay, so the Chief Justice is at the top.
Okay, so that would be Michael Barnett. Okay.
Yeah, and then you have the Court of Appeal, the actual judges that sit. And you know, they just appointed a new Deputy Chief Justice.
I didn't know.
Yeah, Michael, oh, looking right at him, Bernard Turner, who was just appointed last week.
So he's specifically just for the Court of Appeal, or this for like Supreme and all them other places?
What do you mean, the Chief Justice?
Michael Barnett.
No, he sits at the Chief Justice at the Court of Appeal.
Oh, okay. All right. So they're separate. Okay.
Uh-huh.
Okay, I was trying to understand that. Okay.
So the actual Privy Council, they have sat in the Bahamas on several occasions to hear matters. But as you know, matters can be referred to the Privy Council because it's the highest court of the land.
Do they decide? I mean,
Yes.
do they decide
Uh-huh.
if like when I say what I mean, like, okay, is it like I decide if I even want to hear your case or not?
Yes,
Or-
they can. Yes.
okay.
Because they have rules and you have to follow the rules. So not because you applied means that your matter will be heard. Sometimes
Yeah,
the
that's
matter
what
is
I'm trying to
sent back. Right. The matter is sent back.
Alright. Interesting.
Yeah. I mean, you can always go to the Privy Council site and you'll see different cases that would have been brought up before the Privy Council, not just from the Bahamas, but other Commonwealth nations. And you see where they will speak to the rules and the rules being followed. And when they're not being followed, then they will tell you that the matter will not be heard. So let's talk about, that's just the legal system, just an introduction. So now let's talk about doing business in the Bahamas. So when you do business, there's always some legal consideration. And there are three different types of three different roads you can take to go into business. You can either be a sole proprietor, or you can enter into a partnership, or you can form a company. Which one you think is better? Everybody knows the difference between the three?
Good evening. I feel like all would have their strengths, but depending on the case by case, but a sole proprietorship would probably be the best. I feel so because it's the easiest to start and set up without any headaches or worry about a partner, and should be the easiest to operate.
Okay, well, that's one way to look at it. Yes, sole proprietorship is easier because you could just decide that, okay, I want to form a business and do a trading as, and you can go to the Department of Inland Revenue site, do your registration of your business name and all of that. And you can go to the registrar of companies for whatever name you want. But if you're doing a trading as, you do it right on the government website. You could, I guess, start your company up very quickly after you've gone through all of the other government departments to get your approvals, environmental health, and get your NIB, and then you're good to start business. But there are some drawbacks. Now, if you want to stay as a small business, then sole proprietorship is good. But what you say your business is really taking off, would you remain as a sole proprietorship?
No,
No.
definitely not. You would definitely want to incorporate and become a company.
Yes. And the reason for that is because you then be able to get investors into your business and your liability will be limited. Always remember, when there's a sole proprietorship, if there is any liability, that liability is against you personally. Whereas if you form a company, then the liability, your exposure is only to the amount that you invested in the company. That is the shares that you paid for. That's the difference. So you really have to think about, yes, forming a company is more expensive. You really do have to outlay a lot of funds, because you're gonna have to form the company. You have to incorporate the company. You have to have the memo and arts. You're gonna have to get the name. You're gonna need an accountant. You're gonna have to get your staff. Make sure your NIB is paid for all of your staff. You're gonna have reporting. You have VAT also, depends on the level of income. So it is different. It takes a little bit more time, but the advantage of it is that your liability is limited. So what about a partnership? If you prefer the sole proprietorship and you don't want to go straight into a company where you take your interest in the company and then you form in the interest in your trading as, then you form a company and you have shares in the company. You decide instead that, guess what? My wife and I and 2 other friends are going to form a partnership. What's the advantage of doing that?
One of the advantages of a partnership is that you can have basically limited liability to the amount that you invested in the company.
You sure? Because don't forget, now in a partnership is joint and several. So
Your
unless
liability is split.
your liability is split. Yes. And sometimes it depends if the other partners say that they were not involved, then what happens to you? And then don't forget now, if you have a sole proprietorship and you die, what happens to the business?
Business
The
dies as
business
well.
continues. No,
Right.
it continues to carry.
No, how?
No, if you said this is a joint, a
No.
partnership.
If you have a sole proprietorship
Oh,
and you die, that's it.
that's it.
If you
That's
have
it.
if you have a partnership and one partner dies, what happens?
The business carries on.
Are you sure?
Well, they would have to dissolve it and then kind of start over with those that are left for the most part, right?
Exactly. Whereas if you have a company, what happens?
It goes on and
The company goes on.
Mhm.
So even though, again, a company is expensive, with a company, you have perpetual succession. Because the company, and until that company is struck off, the registrar, the company just keeps going. And that's another advantage. So I know Bohemians love that sole proprietorship, but forming a company is so much better when it comes to liability and for the continuation of the business. So if I go back to Johnson, have we convinced you, or you still think you should do a trading as?
No, I was with I was with the company aspect of it. I with that.
Okay, all right. So that's another thing that you have to put in your mind in terms of this whole certification that you're obtaining. You're gonna have to advise people as to what's the best way either to start a business or to continue a business. So far you've learned a lot of things in terms of how to calculate different figures and how to look at risk. But now you need to figure out now, when I begin to advise people, what's the best route to take? Should I advise them to be a sole proprietorship until the business gets started? And then I advise them that they need to form a company and then give them the advantages and the disadvantages. So let's leave that topic by itself, because we're going to come later down and we're going to look at investments and companies itself and what's necessary to form companies. But let's look again from a Bohemian perspective about people wishing to come to the Bahamas and do business. So the first thing when someone comes in, they always ask, and you see that in any country, anybody going to, the first thing you want, if you're going to emigrate to Canada, what's the first thing you ask about? Residency. If someone wants to come to the Bahamas, the first thing they're going to ask is about residency. How do I become a permanent resident? Who could tell me? How do you become a permanent resident in the Bahamas?
I think I knew to like have land or something, something like that. But invest in land or something. Did I say?
You mean invest in land and something and something and something?
I remember I remember learning about it at one point, but I don't remember in detail. I do remember something about land, like Bolivia or
You remember
something,
something about land?
or reside. I don't
Mm.
know, something like that.
You're a Bahamian, you have to be able to promote the Bahamas.
Well, you can get married to a Bahamian. That's one way.
Of course. So that's the first way. And you know that caused a lot of problems in the Bahamas in the past, because a lot of people were getting married to Bahamians, but they were not getting married for love. They were getting married for status. So there's a lot of issue now with foreigners marrying Bahamians. So they say the spouse of a Bahamian after 5 years of marriage, whose marriage is subsisting and the couple cohabiting as husband and wife, not living separately, husband and wife. Persons born legitimately outside of the Bahamas to a married woman who is a citizen of the Bahamas and whose husband is not a citizen of the Bahamas. Financially independent individuals. Here's your part, Kermit. Who are or investors who are legitimate owners of a residence in the Bahamas, and that's purchasing a residence of 1.5 million or more, and that will get you a speedy consideration. Police and prison officers employed in government services for a minimum of 10 years. Teachers, go ahead.
Sorry, my question. So the bigger the house, the faster the application
Yes,
would.
yes,
Understood.
yes. And I don't want you, even though you would see comments may be made locally, and when there are scenes that come up that speak about conflict of interest, and people would, not just locally, but internationally, would talk about this residency and the cost of homes. This is a feature that is across the board in most countries. Bahamas is not the only country that does this. Other countries do the same thing. You purchase a home at a certain value, you get your residency. So nurses employed in the government service with private hospitals and healthcare facilities for a minimum of 10 years. Of course, you can see when you look at all of these, unless you're getting a home for value over 1.5 million or higher, or unless you've been married to a Bahamian for 5 years, these other ones are for a very long time, 10 to 20 years. Doctors who've been employed for 20 years, Haitian national, who are able to provide documentary proof exclusive of Haitian passports and that the department accepts as evidence on the cover of an affidavit. And they've been continuously in the Bahamas prior to January 1985. And of course, persons who have held legal status as a work or resident permit for more than 20 consecutive years. And again, don't feel like these requirements to become a permanent resident are something that only the Bahamas has. So annual residence permit. Persons who wish to reside in the Bahamas on an annual basis can qualify under one of 4 categories. The spouse or dependent of a citizen of the Bahamas, if married to a Bahamian citizen, you can get a resident spouse permit if the marriage existed for less than 5 years. The permit will be valid up to 5 years. And of course, you can make an application for permanent residency after the 5 years or more of marriage. The second way is the spouse or dependent of a permanent holder. They can make an application for the sponsor's work permit or permit to reside, or they can ask for certificate of permanent residency or other lawful authority to reside in the Bahamas. Then you could have an independent economic resident, that along with a financial reference from a reputable bank. And that's normally done by the head of the household. Then you could have resident homeowners. And these are non-Bahamians who own second homes in the Bahamas. And they could apply to immigration, or what we call an annual homeowners residence card. The card is renewable annually and entitles the owner, their spouse, and their minor children. They can travel with the owner and they can enter freely into the Bahamas. Successful applicants in any of these, any one of these categories are not permitted to work in the Bahamas. Work permits. Now, the government recently increased the fees in 2018 on the majority of these work permits. And you remember that there was a cry from the Bohemians that a lot of work permits were being issued, and they went behind and they started to look at all of the criterias and I guess made a decision as to which one should be increased. So wherever work permits are being granted, each employer is required to identify a suitable Bohemian to understand the expat's position within a reasonable time frame. So that means that when you hire an expat, you're supposed to have a Bohemian who works along with that person, and that Bohemian should be able to take over that position within a reasonable time. So an employer may obtain permits for longer
Sorry, Ms.
periods.
Hacho,
Yes.
question, who monitors that right there that you just said?
I think it's a dual responsibility between the employer and the Department of Immigration.
That does not happen. That
I know it
not
doesn't happen. And so it doesn't happen, right? So let's look at it from a place of employment. You are working in a place and there is someone, an expat, and you know that you're in line or you should be in line to get that, but there are certain things that you need to learn. If you're not being taught these things, what do you think you should do as an individual and a citizen of the Bahamas? Because you could either do one of two things. You could either bring it to the Department of Immigration attention anonymously, or you could sit there and let that foreigner stay there forever until they retire.
So,
Because they keep saying that you're not ready. And you're not ready because
suggestion-
you're not being trained.
So in a situation like that, your suggestion would be to go to the Department of Immigration first, or bring it to the attention of, let's just say your employers, letting them know that, hey, this is the situation, or don't do that because you could lose your
Hold on.
job.
Your employer and their human resources department is well aware.
Yeah, I know
what
they
is
should know
required.
that, but I mean, I know that there are some companies who believe that persons don't know some of this information.
Mm-hmm.
So let's just say they thought I did not know,
Right.
and I bring it to their attention. I just feel like that's cause for nitpicking
Yes.
maybe, or they basically
No.
they
No.
try to find something and let you go.
Well, it is okay. I'll say the
That's
way
kind of
some,
tricky.
yeah, I'll say it the way one of the leading bankers said at a presentation when someone asked a question, and he said, you know, there comes a time when you have to make a decision. Either you stay and you do as they say, or you report them and you leave the job. The decision is yours. So the first thing you would do before you even go to them is to see whether or not your job description includes that provision in there that you're supposed to be this person's understudy. Because if it isn't there, then you need it to be there. Because then that tells you that, guess what? You have the right now to say at the end of the year, guess what? Mr. Wood did not or is not showing me how to do this job. And it is a part of my job description. Because it says here, that renewal of these work permits is not automatic. So no expat can be continually employed in 5 years, but note that they are promoted. Or they say that the Bahamian is not ready. So you have to begin to put the steps in the ladder in order, in the view of human resources, that you are doing what it takes to get there. So you will have a leg to stand on when you say, hold on, this man is not teaching me anything. This is a part of my job description. I'm supposed to take over this position in 3 years or 5 years, and he is not showing me the first thing in 1 year has gone by. So there have been people who have reported expats to immigration.
Okay.
All right. So work permits were increased in 2018, and I've given you a listing of them. And just to give some examples, for VPs and CEOs and CFOs, presidents and managing directors, the fees went up to 15.5. For dentists and casino managers and doctors and editors, it went up to 12.5. But that has not stopped the applications. Fees for sous chefs, wine stewards, and chemists, and pharmacists, that went up to 9. For barbers and assistant chefs, pilots and butchers and croupiers, nurses, hotel managers, that went to 7.5. Doctors and consultant, the cost is now 6,250 because it wasn't included before. Bartenders and butlers and carpenters, from 5,000 to 6,000. For teachers, 4,000, from 4 to 5. For housemen and head gardeners and cigar rollers and receptionists and sales clerks, from 3,000 to 4,000. For gardeners and handymen and hotel helpers, that stayed at $1,000. And any non-Bahamians who are desirous of working and living in the Bahamas for a period greater than 90 days must first be authorized to do so by way of a valid work permit, visa issued by the Department of Immigration. And persons wishing to work for up to 90 days must apply for a short-term work permit or visa. And I gave you the documentations that's required.
So, Ms. Archer,
Yes.
so when you say they have like 3 or 5 years, and before they could be, they have to go or exit the position. Is it the individual or the position itself have 5 years for any foreigner to be in it or whatever like that? Or is it the individual that came into the position? Their thing only have 3 to 5 years to do it.
No, what you mean? Because if you hire someone as a CEO, right? When that work permit 3 years is up, they apply for a renewal.
Because I'm thinking certain places like Scotiabank, them managing directors, them people them must come. I mean, they don't always have to see in person, but they always be expats at their senior positions in certain banks and stuff like that. They always. That's what I'm trying to figure out. Is it for the position itself, like the CEO? They could let this person go after a three-year term up and then bring another foreign person, or is it, the person only have 3 years to do the job?
No. If you take Scotia had Bahamian managing directors.
Oh.
So it wasn't depend. Yeah, that rotation at Scotia doesn't work on our immigration policy. So you could be a managing director and you could stay for 5 years. You can stay for 7 years, but each managing director has a mandate. So your appointment is based on your mandate. So whatever it is that they have hired you to do, That is how long you stay in that jurisdiction. Now, versus if you look at an offshore bank, when an offshore bank brings in a CEO, they'll bring in a CEO and they say that CEO is here for 3 years. And that CEO is here to train a local Bohemian. So when that 3 years is up, if that local Bohemian in their view is not ready, they will put in an application for renewal. And immigration will call and speak to the Human Resources Department to say we have an application. And Human Resources has to say, we don't have anyone else, anyone who is ready to fill that position.
Okay. So so they could put a Bohemian in place and then switch back to foreigner. They could do that.
Yeah. Because if you have a Bohemian in place, right? And let's just say that Bohemian had a mandate and they're not fulfilling their mandate. They are unable to complete whatever targets that the international body has asked them to do, the parent. Then what they're going to do? They're going to look around for other candidates within the organization. They may take a chance and get another Bohemian. But if they have other candidates in other locations who are ready to be a managing director or CEO, they will take one of those. And be careful now, because when you're talking about international organizations, there's a lot of weight politically. You don't want to antagonize your foreign laborers and your foreign investors.
I just still want to put Bohemians first.
That is a slogan.
I mean, because I'm just trying to. I mean, because okay, I follow the rules. I put a Bohemian there, and then I don't like it, so I bring in a foreigner. And then I is the goal should be to have Bohemians there on a like on a regular basis, not just a pretty, and then you put another foreigner friend there when you're ready.
No, business don't work like that. If I own a bank here in the Bahamas, right, I got a Bohemian to run it. I had a foreigner first. They set up everything the way I want it done. And they say, okay, Kermit is ready to take over. He's been training under me. I'm going to let Kermit run it. So now I send my mandate down to you, what I want you to do. I want you to open another office in Grand Bahama. This is my budget. You decide whether or not you leasing a building, whether you're renting a building, find the right people, and this is your target. This is what I need you to make in the first year. You don't succeed. I've lost trust in you. And I've lost trust as to the person who's going to be next in line from you, or candidates that they have sent to me. I doubt that they're going to do what I want them to do, because I have a target and now I am behind. So you know what? I have 3 people, one in St. Lucia, one in Barbados, and I have one in Jamaica. They are go-getters. They have met their target. I will bring one of those in for 3 years. Hopefully, they'll be able to identify another Bohemian. If they can't, I will get someone else from another jurisdiction. Because they have to make money. They're in the business of making money, not making friends.
Okay.
Okay? So resident spouse permit, foreigners who are married to Bahamian nationals are eligible for resident spouse permit. And this permit allows the spouses of Bahamians to legally work and live in the Bahamas, provided that they live with their Bahamian spouse and they have been married for less than 5 at the time of the application. Note that once the 5 years of marriage is passed, the non-Bahamian spouse may apply for resident spouse permit citizenship or permanent residency. And then permanent resident, In 2018, the work permit fees were increased and as follows. If an applicant who has resided in the Bahamas for at least 10 years, but less than 20, and they hold a work visa and is not a teacher, not employed as a police officer, prison overseer, or a nurse, they will pay $7,500, and that's up from the $5,000 for a permanent resident certificate. And so you can see that just by the increase of these fees, if you go down, that this is a source of income for the Bahamas government. See, the wife of a Bohemian citizen will pay $1,000 for permanent residence instead of $250. A person seeking permanent residence will now have to pay $15,000 instead of $10,000. Prison overseers or any other non-professional government contracted officer who reside in the Bahamas for at least 20 years and holds a work permit will pay $1,000 instead of $500. And it just went down the list. So let's talk about Kermit, the part that you like. Under the National Investment Policy, the minimum investment for the purchase of a residential home is $1.5 million. And that's so you can meet the requirements for accelerated consideration of permanent residence in the Bahamas. And you notice that a lot of these high-end homes are being constructed in the West, in the gated communities. So not only must they invest 1.5 million or above, but they also have to be fit and proper, which means that due diligence have to be carried out on these individuals to make sure that they're not being sought after by the CIA, the Interpol, or any other policing authority. So whoever is the applicant, know that they have to meet the other immigration requirements for permanent residents. And that means that they have to have good character and they have to be able to show that they can actually support themselves. And that's the criteria in most countries when you're seeking permanent residency. You have to be able to support yourself and be of good character. The applicant must state that they intend to reside in the Bahamas permanently. And the application for permanent residency will be made under the category of economic applicant because they are purchasing a home of the value of 1.5 million or above. And then I gave you the documents that's required. So what are the benefits of obtaining permanent residency in the Bahamas? You have a right to reside in the Bahamas without further renewal of permits. You're eligible to apply for citizenship of the Bahamas after you fulfill your residency requirements. You don't have the right to vote, but you can enjoy the same privileges as a Bohemian. You have a liberal tax regime. You can purchase property in the Bahamas, and you are able to travel throughout the Caribbean because we are a member of the Commonwealth countries and a member of the OAS. So you're free to travel. A permit to purchase property or acquire property is required by all non-Bohemians if the property is undeveloped land. A permit is also required by a non-Bohemian who intends to acquire an interest in land in 2 or more adjoining acres. The Bohemians are also required to apply for a permit where the intended use is not as an owner-occupied property. And then there's an application fee. So under the International Persons Landholding Act, a non-Bohemian or permanent resident who purchases or acquires an interest in a condo or vacant property to be used as a single family dwelling or for construction of such a dwelling has to apply to the Bahamas Investment Authority to register that purchase. So persons who are eligible include non-Bahamians acquiring an interest in land or condo to be used as, like I said, an owner-occupied property, permanent residents of the Bahamas, non-Bahamians who are acquiring an interest in land under device or by inheritance, non-Bahamians acquiring an interest in land by virtue of any court order or as a mortgagee, or non-Bahamians acquiring leasehold interest for trade or business for a period greater than 21 years. And I gave you the documents that's required. Homeowners card, any non-Bahamian who owns property on any of the islands is eligible to apply for homeowners card. And the process is a letter of request is sent to the Director of Immigration, and you attach your supporting documents to the letter and you submit it to the Immigration Department. Stamp tax on real estate transaction. There is a 2.5% government stamp tax is charged in all real estate transactions under 100,000, and a total tax of 10% on all real estate transactions valued at 100,000 and over. Unless otherwise agreed, the stamp duty is split 50-50 between the buyer and the seller. For owner-occupied property, the first 250,000 on an owner-occupied residential property is tax exempt. The next 250 is 0.625%, and then over $500,000, the tax rate is 1% of the remaining value or part thereof. If you have residential property that has 4 units or less and is being used solely as a dwelling place, the first 75,000 is a flat fee of $300. Anything above that, the first 75, then the balance is 0.625%. Commercial property, if it is 4 units, even if used as a dwelling place, the first 500,000 is 0.75%. Property value over 500,000 is 2% of the remaining property value. Vacant land for foreigners, the first 7,000 is $100 flat fee, and after that is 1.5% of the remaining property value. Now, there are exemptions. Property owned by the Bahamians and situated in the Family Islands is exempt from real property tax. However, property approved as commercial farmland is eligible for property tax exemptions, and only foreigners pay on the Family Islands. They are also exempt from real property tax. Unimproved property owned by Bahamians, meaning property without any physical additions or alterations or any work benefiting from the land which have increased the market value thereof by 5,000 or more, is exempt. Property used exclusively for charitable or public service and where there is no profit is exempt. Properties located in Freeport and Grand Bahama under the Hawksbill Creek Agreement are exempt. Any building that's registered under the National Register of Historical Buildings are exempt from real property tax. And exemptions are not automatic. You actually have to apply to be listed. And the person who's applying has to be, the applicant must be the owner of the historical site. And then the building has to be registered on the National Register of Historical Buildings. You all know that real property tax is paid to the Department of Inland Revenue, and no VAT is added to real property tax because it's already a tax. Senior citizens have a benefit from real property tax. After $250,000 exemption, there is a 50% discount on the balance of the home value not exceeding $1 million. But the person has to be 65 years of age and have an NIB senior citizens card. If full payment is made by the 31st of March, they would get a 10% discount. And of course, I know you are aware that the 12% VAT is charged on real estate services, including appraisals, legal work, and commissions. So for those who wish to purchase property, because you may probably be able to give advice to someone who wants to purchase property, and they will be going through a real estate agent. There is a cost associated with that. The vendor and the purchaser has to pay half of the stamp duty. That's the typical way you do a transaction. The VAT is payable on a conveyance, must be paid to the VAT controller, and thereafter to the public treasury for the payment of stamp duty. If the VAT controller is not satisfied with the consideration amount, one must produce the appraisal report so that they can get the true market value. The commission on the sale of developed land is 6% of the gross sales price. And the commission on the sale of undeveloped property is 10%. And then VAT of 12% is added to the fee. So now you can see why a lot of people are going into becoming real estate agents. 1/2 of the government stamp tax. This is a graduated fee, and the total amount of the tax is the value up to 20,000, the rate is 4%. Anything greater than 20,000, but less than 50,000, the rate is 6. The value greater than 50,000, but less than 100,000, the rate is 8. And of course, anything over 100,000, the rate is 10%. The vendor's legal fees, VAT is added to that of 12%. So legal fees are normally 2.5% of the first 500,000 and 2% of the next 500,000. 1% of the next 4 million and 0.5% thereafter. Government stamp tax of 5% is also paid, and the purchaser will be responsible for 1/2 of the government stamp tax, the purchaser's legal fees, the recording fees for the conveyance, and any other closing documents, and then payment of the permit for the International Persons Landholding Act. So the next thing I did was I just set out some questions that normally asks about the Department of Inland Revenue with regard to VAT. Any questions on those questions or clarification you need?
So far, so good.
Okay, because
No.
everybody should be familiar with VAT and what's required. So my next section is the fundamentals on purchasing property. And anyone in class who has never purchased a piece of property?
I've never purchased a piece of property. I'm interested.
You're interested.
I purchased the property than Miss Archer.
Why not?
Because it ain't for free.
Good answer. Good answer. Good answer.
Okay. No. Okay. Purchasing a property connotates that you're going to pay for it, but someone can gift you a piece of property.
Could you find me that gifter, please?
Most likely it's a relative.
Mm. I've never purchased a property, but I've dealt with mortgages in the bank and then selling repossessed properties in homes.
Okay. All right.
So yeah. So
yeah,
that's
so
where
you close. You're right.
Yeah.
All right. So when you think about you want to purchase a piece of property, the first step is you need a sales agreement. And that sales agreement is a contract between the buyer and the seller. And in that sales agreement, it would contain what's the purchase price, the deposit that's required, the completion date for the agreement, the obligations of the seller, the undertakings by the attorneys on both sides, and then the consequences of what happens if the seller fails to give you a good title on that property. Or on the opposite side, what if the purchaser is unable to obtain financing for the property if they're going for a mortgage or for a loan? So the deposit is normally 10%, and that's often paid by the vendor's attorney, paid to the vendor's attorney at the date of execution of the agreement for sale. And that 10% is held in escrow until the actual contract is completed. After execution of the agreement for sale and the receipt of the original or copies of the vendor's title documents, and we're talking about the title documents to the property, the purchaser's attorney investigates the title to the property, and they do that by conducting what we call a title search. The first search they do is they check the Supreme Court cause list, which means is they check the list of the Supreme Court to see if there are any judgments or any pending matters before the court that relate to that piece of property. They also do a search of who are the previous owners of the property. By law, when you're deducing title, This means you're trying to find out who was the previous owners. You have three choices. You can go back 30 years, or you can go back to the latest time when the Crown, that's the government, would have granted a lease to that piece of land, or you go back to the time when that land was quieted by an individual. Whichever period is shorter. You don't go back 100 years. You don't go back 50 years. It's whichever one of those three is shorter. The purchaser's attorney may ask some questions on the title of the property. And then the vendor's attorney has to provide those answers. The agreement for sale normally provides for a specified period, and that's normally 14 days from receipt of the title documents for any requisitions, which means that any queries by the purchaser's attorney after investigating the title. So any question that the purchaser attorney has on that title, he has 14 days to put those questions forward to the vendor's attorney. Certain requisitions on title itself, the purchaser's attorney may raise questions on the requisite government and subdivision approvals. He can also ask about real property tax assessments, whether there's outstanding utilities, and the survey of the property. He can also ask if there's any right of way, any permanent easement, which means there's anyone who has permission to actually use a pathway on your property, or if there are any restrictive covenants. Restrictive covenants means that there are in the original documents, when the property was sold originally, the first owner may have said that this property may not be used for a particular purpose. And those restrictive covenants run with the land. And so all of these things, the purchaser's attorney has to discuss with the vendor's attorney. So once the purchaser's attorney is satisfied and all their questions are answered, then the purchaser's attorney will prepare a report, or what you call an opinion on title, for the purchaser and the bank. The draft conveyance of the property that's normally prepared by the vendor's attorney may also be reviewed at this time, and the requisition, the title, and the costless searches by the purchase attorney or any other subsequent requisitions. The conveyance, of course, will include the names and addresses of the parties, any references to any earlier documents, a description of the property, if there are any restrictive covenants or easements or any rights of way. It would include a plan of the property, affidavit of citizenship if it's necessary as a non-Bahamian, any other relevant information that's applicable to the conveyance. So once it's amended and approved, the conveyance is finalized by the vendor's attorney and executed by the vendor and the purchaser whose signatures are witnessed. A completion statement is prepared by the vendor's attorney, and the balance of the purchase price is paid by the purchaser's attorney. Less, of course, the vendor's portion of stamp duty and any other apportionment for outstanding fees, such as property tax or utilities. The legal fees, like I said before, is 1.5% to 2.5%. And these are paid on or before the completion by the vendor and purchaser to their individual attorneys. The commissions to real estate agents are also paid at this time. Requests are made to utility companies to return deposits to the vendor, and then all utilities and real property tax assessments are placed in the purchaser's name. The conveyance is sent for stamping at the public treasury, and the stamp duty is paid on a conveyance, which is normally split between the vendor and the purchaser, and is based upon the total consideration or the purchase price of the property. So under the Stamp Amendment Act, application for exemption from stamp duty on the acquisition and mortgage of property may be made for and on behalf of first-time owners of a dwelling house valued at $500,000 or less. After stamping, The title document is sent for recording at the Registry of Deeds and Documents for a nominal recording fee. So the sale and purchase of real property is a valuable commercial experience for all parties involved. And with the appropriate knowledge and understanding of the conveyancing process, the vendor and the purchaser can effectively and efficiently transfer title to property with more ease, flexibility, and skill. Anyone in class interested in becoming a real estate agent?
Yes, ma'am.
Okay, because once you finish this last section that we're doing here, you're gonna see there are a lot of different avenues you can take with the certification in order to build your portfolio and start your own business. So the next section is a guide to understanding mortgages. So Johnson, you say you know all about mortgages, right?
You don't have to put me on the spot like that. I know some of it, a good much of it. I can say I know a lot.
Ah, okay, all right. No, I was not putting you on the spot.
Oh, that's good.
Okay, so when you would have purchased a piece of property, the first thing you have to realize is that when you purchase property, you do not own that land. You own an interest in that land. So a mortgage is an interest in property. And when you apply for a mortgage, then you create a form of security for a loan by the bank holding that property until that debt is terminated. The borrower who offers and grants the mortgage is called a mortgagor. And the lender who provides the money is the mortgagee. So there are two types of security over land or real property. You could have a legal mortgage or you could have an equitable mortgage. A legal mortgage confers a legal interest on the mortgagee and can only be granted by a mortgagor who has a legal estate in the land. So what does that mean? That means that when you purchase a piece of property and now you want to build on it, you apply to the bank for a mortgage. In order to do that, the bank takes over the legal interest on that property. An equitable mortgage confers an equitable interest on the mortgagee. And that also may be granted the mortgagor who has a legal estate. But if he has only an equitable interest, for example, a beneficiary under trust, and we're going to do trust later. So if you are a beneficiary under trust, you do not have a legal interest. You only have an equitable interest. You can also have an equitable charge, which confers an equitable interest on the chargee, but is more limited rights than an equitable mortgage. So the first two types of security are typically used by mortgagees, particularly financial lending institution, because they're more attractive and there are remedies that goes with it in the event that the borrower or the mortgagor does not pay. So a mortgage document specifically describes the parties to the transaction and the terms and the conditions upon which a mortgage is granted over the property by the mortgagor and upon which the loan is given to the mortgagor by the mortgagee. It's prepared by an attorney and is usually executed by the mortgagor. No questions there, right? The
Crystal
mortgage
clear.
document, okay. So the mortgage document also provides a detailed description of the property, the duration of the loan, the amount of the monthly payments, the date of the payment, and of course, the mortgage's redemption of the mortgage upon repayment of the loan. And of course, it tells you the events of default. It also will give you inside the document the covenants by the borrower and of course, the rights of the lender. An opinion on title confirming or attesting to the validity of the title to the property is issued by an attorney to the mortgagee, and that's normally the lending institution, before completion of the mortgage transaction and before approval is granted for the loan to the mortgagor. It's important that the mortgagee satisfies itself that it is legally in a position to grant the loan. And particular attention is given to the fact that it is not adversely affected by the rights of persons other than the mortgagor. So that's one thing that the bank has to make sure. One, that the person who is applying for the mortgage is actually the rightful owner of that property, and that they have the legal right to engage in the mortgage. The mortgagee protects the security rights over the mortgage property against third parties, such as subsequent mortgagees or purchasers of the mortgage property, by recording or registering its security over the property, by having the mortgage document stamped at the public treasury and lodged for recording at the registry of deeds and documents. Always remember, when it comes to legal documents, you have to register that document, because the registration is what is needed in case other persons want to claim against that same property. So even when you get a conveyance, it has to be registered. You can imagine if someone decides to sell the same property to 2 or 3 persons, who you think actually owns it at the end?
The institution that registered the mortgage first.
First, yes. So mortgages rank in order of priority according to the date of recording of the mortgage document. So according to Bohemian law, the first mortgagee in time takes priority over subsequent mortgagees. So when the mortgagor has paid off the loan and the property becomes free of the mortgage granted over it, the mortgagor has effectively redeemed his property. So during the currency of the mortgage, the mortgagor has residual rights in the property known as equity of redemption. So equity of redemption means that you have a mortgage. Let's say you got a mortgage for $60,000 and you have paid off so far $30,000. And so your equity of redemption is $30,000. Of course, you can actually apply to the bank for more than the $30,000 or the difference, and where they'll have to do an upstamping. But of course, you'll have to get an appraisal first. Right, Johnson?
Correct.
Okay. This is where a lot of Bahamians trap themselves by continuously getting new loans based on their equity of redemption. So the value of the equity of redemption is really the mortgagor's unencumbered interest minus the value of the mortgage loan. So the law governing mortgages in the Bahamas have ensured that the mortgagor is protected from any undue advantage by the mortgagee by ensuring that if a transaction is in essence a loan on a security, it is treated as a mortgage. And notwithstanding its form or the words of the mortgage contract, and by ensuring that there are no clogs or fetters on the equity of redemption. So you see why when someone says, okay, I have $20,000 equity in my home, and they go to the bank, as long as they can meet the criteria for that deduction, there's really nothing that the bank can do, because the bank cannot clog or fetter the equity of redemption for a borrower. And similarly, the courts have been cooperative in assisting mortgagees in exercising their legal rights and remedies against defaulting mortgagors. So, you know, there are remedies when the mortgage is not paid after 3 consecutive payments. On the 4th one, then the bank then decides to take action. So I mentioned a trust earlier when I said that if you are a beneficiary of a trust, you will not have the legal interest in that trust. You only have an equitable interest. So you may have someone who is wealthy in Bahamian terms, and they want to establish a trust. Why would someone want to establish a trust? Anyone have any idea why someone would want to establish a trust?
To hide.
Hide.
Certain assets.
Hide. What you mean hide? Why you say hide? Why you like the word hide?
I can't remember the term. I used it today and I felt so smart. Now I can't recall it.
But it wasn't hide. It wasn't
No, it
hide though. It
wasn't
was
hide.
something else.
It wasn't hide. It wasn't
Mm.
hide. Not
Okay, let me
evade.
go. Okay,
No.
let me go to the fellas then first, because they will be thinking about these things. Why would you establish a trust? And who would you establish it for?
I guess to make sure if you have kids, to make sure that they get whatever it is that you want them to have.
True.
That's an option.
Mm-hmm. Any other reason?
With a trust, you have your property and everything moved into it while you're alive, and you could designate beneficiaries and how you want everything to be distributed. And it's not really contested like how a will could be contested in the court.
Exactly. Mm-hmm. Yes, we're gonna do wills later down.
Also, I
you'll
think
see.
a trust can be managed while you are still alive. So you can
Yes.
still give directions or directives through the trust.
Yes, you'll give that at the time of setting it up. Okay, so for the men, I mean, women do trust too, but you see more men. So what happens is that you have assets and you've decided now that you have assets and I don't know, you may have some apartment buildings, you may have businesses, properties, cash, investments, and you decided to guess what? Instead of me managing those funds, I would now appoint a trustee to manage those funds and distribute those funds for me. So in a trust, you could have real and personal property. It doesn't just have to be the ones I listed. Some people have paintings, they have boats, they have cars, all whatever your assets are. So what a trust is an actual legal arrangement. And based on that legal arrangement, you would transfer your legal interest to the trustee to manage and administer those assets on behalf of the beneficiaries that you're going to name. Those beneficiaries can be your spouse, could be your brother, your sister, your children, and it can also include yourself. Once that happens, once the assets are transferred in the name of the trustee becomes the legal owner of those assets. You no longer own those assets anymore. And if you are not a beneficiary to that trust, you no longer have a say in how the trustee operates or how he manages those assets.
So I can set up a trust before I get married, transfer my assets, and then I'm like, hubby, I don't run that trust. That's not me.
No, not to say it's not you, because you could be a beneficiary of the trust, but you no longer own those assets.
Exactly, which means
Right.
he would have no right.
Right.
To my assets.
Now, let's just say, let's rewind now. So let's just say you have these assets, you marry this person, and you all work together, and he helps you with these businesses, and you begin to make more money, and then you decided you want to set up a trust, but you didn't put him in it. He can sue you.
There was a case that was just, I heard about it, I think about 2 weeks ago. And then on the radio show this morning on Guardian Talk, an attorney was discussing this huge land breaking case where the same thing happened. A husband and wife She was a homemaker for 30 plus years. The husband, with her assistance, amassed great wealth. And he then, right before the divorce, transferred ownership of all of the assets into his company name, which was separate and apart from his wife.
Yes. And she sued, right?
Yep.
And she won, right?
She did.
Okay. So that's what I thought. That's what I thought the men in the class were going to say. But they didn't catch on to the trust yet. They didn't get it yet.
Don't worry, I get you.
Okay. Because it can be used for different reasons, but you cannot do it after. You see, because two laws are coming in. You have the Matrimonial Act, and then you also have the Trustee Act. So even though that trust is set up, and even though he probably would have set that up as to say, this is how he no longer has legal interest in it. When he transferred that from the matrimonial side, she had an interest. So whenever you want to set up a trust, there are different types of trusts. The one most of the foreigners come to the Bahamas for is what we call a discretionary trust. And a discretionary trust means that the trustees make all of the decisions. Decisions in terms of who receive benefits, how the assets are to be invested. They could also make decision as to when you are to be paid. They make a decision as to who to pay. That's a discretionary trust. Then you can have a non-discretionary trust or fixed interest trust. And so this is a trust where what the settlor does, the person who's established the trust says that, guess what? Twice a year, I want you to pay Keva $5,000. And it's fixed. A part discretionary, part fixed is the trustees make a decision at times, and then there's also a fixed amount that you get. And that may not necessarily be twice a year or once a year. It may be once every 5 years. It depends on how the settlor sets it up. Of course, a trust could be revocable or irrevocable. So revocable means that the settlor can cancel it, and he can cancel it in whole or in part at any time. And then the trustee could reconvey it or transfer the ownership of the assets to the settlor on the revocation of a trust. An irrevocable trust means it cannot be canceled or revoked by the settlor. So some of the advantages of establishing a trust, because it is used as an estate planning vehicle. So first thing is, if you establish a trust, you don't have to worry about probate. And we're going to talk about probate later. A trust is also a confidential document and is not required to be filed publicly. Your will is required to be filed, and it is public, unless, of course, if it is contentious. Then it's under lock and key. A trust affords a person planning his estate the expertise of a corporate trustee, which means that when you establish a trust, that trustee has the expertise in order to fulfill your wishes. A trust affords certain insurance options, such as distribution of insurance proceeds and benefits. A trust avoids delays in beneficiaries receiving assets. And a trust may be used to protect assets from creditors. So if you establish a trust as an estate planning vehicle, it has become both easy and affordable today due to the growing number of financial institutions who offer this product. And the trust may become the vehicle of choice by many persons wishing to effectively make financial provision for their families and friends during their lifetime, and in some instances upon their death. Because you can set up the trust and you can say for my children and my children's children or my heirs. Transfer of trust. One of the features of a trust is that you can transfer your trust from one jurisdiction to another jurisdiction. And normally to do that, it has to be a provision made in your trust deed, allowing you to move from one jurisdiction to another jurisdiction. So if you're going to move from one jurisdiction to another jurisdiction, you normally make sure that the laws in both jurisdictions are similar, because you can't transfer it to another jurisdiction where the laws are different. So normally it goes from one common law jurisdiction to another common law jurisdiction. And you take a lot of things into consideration, such as the place where the actual administration will take place. You look at where the assets are situated. You look at where the trustees reside, and you also have to take into consideration the residency of the beneficiaries. Because remember now, when you think about dispersing funds to a beneficiary, there are a lot of things you have to take into consideration. And one of those is their taxes. So you always have to look at what is the proper law of jurisdiction for the trust, and to make sure that the beneficiaries are protected, especially if there is a dispute, because the local trustees need protection. So a settlor can avoid obvious management and control and taxation problems by appointing trustees who are resident in the proper law jurisdiction. So you could transfer trust from the Bahamas to the Cayman Islands, or from the Bahamas to Jersey. So normally in the trustee, there's some provision that cover the power to change the proper law of the trust to that of another jurisdiction. And that power is normally given to the trustees. So the most common method of transferring a trust from one jurisdiction to another is by having the existing trustees appoint new trustees in another jurisdiction. And then those existing trustees will retire from the trust in what we call a deed of retirement and appointment. So once the existing trustees retire, the appointment of the new trustees, the assets of the trust are then transferred to the new trustees, and it automatically vests in them. But this only happens if the new trustees are resident in a jurisdiction that has trust laws, and those laws are similar or based closely on English trust law, or on the trust laws of the jurisdiction where the trust is being transferred from. Now you can alter the form of the trust settlement to take into account the differences between English trust law and the law of the country where the trust is being transferred. I could do that by using a power in the trust instrument to revoke existing trusts and to declare new trusts. Everything depends on the provisions in the trust deed. If there's no power in the trust to do this, then an application has to be made to the court. So when you transfer a trust from one jurisdiction to another, there are things you have to take into consideration. Again, the similarities and the difference between the trust laws in both jurisdictions. You have to look at the interests of the beneficiaries and whether the change of the jurisdiction or the change of the trustees will either prejudice their interests or be adverse to their interests. You also have to consider the interpretation of certain words compared with other jurisdictions. And of course, the appointment of trustee in the new proper law jurisdiction. Another consideration when you're transferring a trust is the existence of a flee clause in the trust instrument. And that has the effect of changing the management and administration of a trust to another jurisdiction in the event there is political instability, or there is change in the tax regime, or there is civil unrest. trust. So normally the flee clause will include some provision that on the occurrence of some predetermined event, the trustees will automatically retire and new specified trustees will be appointed in another jurisdiction. So it will state that the proper law and the law of the forum will be changed at the same time as the change in trustees. The jurisdiction to which the trust will flee should always have a comparable trust law to that of the former jurisdiction in order to avoid any possible conflicts in the future. And normally, it'd be one in which the original trustees have some representation or office. So new trustees are appointed under the deed of retirement and appointment. And as a matter of good practice, you review the trust laws of the original former jurisdiction to ensure that they are comparable to those of the country in which they are resident. And you always vet the provisions of the trust deed to make sure the provisions of the trust deed are acceptable in terms of the duties, the powers, and the obligations, the risk and indemnities that they will assume in accepting to act as new trustees of the trust. So the next thing you have to look at is, what are the legal elements of a trust? So, you know, there are three parties to a trust. You have the settlor, you have the trustee, and you have the beneficiaries. So if a settlor intends that a trust of property shall arise upon his death, the creation of the trust must be by will or codicil. So there are two ways you can set up a trust. You can set up an express trust, which means that a person walks into a trust company and say, I want to establish a trust. The trustee then would set up the trust instrument, the trust deed, following the instructions of that settlor. Another way a trust can be established is a person in their will. They can write that they want a trust to be created. And then they say what assets the trust should contain. So when a person establishes a trust within a will, they have to follow the laws under the Wills Act. So under the Wills Act, it says to be valid, a will shall be made by a person who is 18 or over, must have sound mind, and the will has to be valid. It has to be in writing, signed at the foot or at the end by the testator or another person in his presence and by his direction. The signature of the testator is effective if, so far as his position is concerned, it satisfied subsection 3. This means that he is disposing of his assets and he's disposing of it at the time of his death. Each witness has to attest his signature. And they do it in the presence of the testator. But no form of attestation is necessary, nor is publication of the will necessary. There must be 3 certainties in place. I mean, you create a trust. So if 3 certainties are not present, then there is no trust. You must have certainty of words, certainty of subject matter, and certainty of objects. Word means that the words that you use in your will must signify that you are creating a trust. And the word trust or confidence don't have to be there. The settlor or the testator, he must know his subject, which means he has to actually know what his assets are and where they are And the third one is certainty of objects, which means he must know to whom he is leaving his property to. If the words are not certain, then the donee or the person who or entity receiving the out there is no trust. If the objects are not clear, the words are sufficiently certain to have created a trust, but the objects are uncertain, then what we call a resulting trust will arise, which means it goes back to the estate of the testator. The next section is on investments, which is another tool. You know, the Bahamas has lots of investments, and there are lots of investment funds. You could have a professional fund, a standard fund, a smart fund, a master fund. A person who carries on this business can apply for a license. So you have a lot of people who have worked in the securities business, and they have decided that they want to start to do fund business on behalf of foreigners. So to be classified as a professional fund and a standard fund, you must have an investment fund administrator, an investment fund manager, or what you call an alternative investment fund manager. The unit trust must have a trustee who is licensed by the central bank and otherwise acceptable, a bank or trust company, and must have a capital of $2 million. A smart fund must follow the perimeters and requirements set out by the Securities Commission. In addition to the definition of an investment fund must have a nexus in the Bahamas to be considered a Bahamian-based investment. So the investment fund is another investment tool that the Bahamas offers to foreigners. So if we look at when we first started, we know we have a common law legal system. We know that the highest court of the land is the Privy Council. And then we moved into, people can look at whether they want a sole proprietorship, a partnership, or they want to establish a company. Then we looked at, if you have foreigners who are interested in coming to the Bahamas, the different routes that they can take. They're either coming as a spouse, or they're coming as an employee under work permit framework, or they're coming as an investor, investing 1.5 million or more under the accelerated program. Then we started to look at, there are different ways that persons can actually come to the Bahamas and start to invest in the Bahamas, or find ways in which they can utilize the funds that they bring. One, they can purchase property as a foreigner under the International Personal Landholdings Act. Or you can take the route to say, there are Bahamians who wish to purchase property outright, or Bahamians who wish to obtain a mortgage to build a home. So we looked at that also. Then we looked at trust. Trust is another estate planning tool that not only foreigners can do, but Bahamians can also use it. And as a means in which you don't have to wait for probate. You can do it now while you are living. And you give all of your legal interest to a trustee who manages and administers that property for you and distributes it according to your wishes. The Bahamas also has investment funds. And a lot of Bahamians play pivotal role in the investment business, investment fund business. So both the investment funds, Bahamians and non-Bahamians, where equity interests are being sold in the Bahamas, has to file a current offering document of the investment fund. So, you know, you have foreigners that invest in these professional and smart funds, and then you have local fund administrators, such as CIFP that invest in various investments, but they're all a part of a fund. Anyone has an investment in CIFP?
Yes, and I work for them.
Ah, see, very good. Very good. So now you see the importance of fund management, because fund management takes two routes, one for foreigners and one for local. So a fund manager has to be licensed and registered in the Bahamas, and their criteria is they're capable of complying the capital assets and organizational requirements. They have to have sufficient expertise, because there is a lot of liabilities and securities. They have to be suitably qualified for the performance of this function and is of good repute. So let me ask you, are you interested in starting your own business eventually in the fund?
It could be a possibility to invest people's money for them.
Yeah, but it is risky.
It can be, yes. Yeah.
It can be risky, especially when you promote at the beginning, you promote a spread of returns. And then when you're not realizing those returns and they're not based on market condition, you could really have some problems.
Yes, I've been in meetings trying to explain those situations to clients.
Yes. So it's a lot. So an investment fund administrator, investment fund is required to appoint an administrator, and that administrator is required to be licensed pursuant to the act. And to act as an investment fund administrator, the person has to be licensed, restricted or unrestricted investment fund administrator. Non-compliance with this may incur a fine of up to $200,000. To license an investment fund administrator, the company may be incorporated or registered under the Companies Act. The act sets out the conditions for licensing, such as sufficient expertise to minister investment and sound reputation. So an investment fund, and as a matter of fact, there have been quite a few funds that have been in the papers for, what would you call it, misappropriation? No. There have been some funds that have been sued from the United States. An investment fund shall renew its license on the 31st of January, and a register is kept by the Commission of Investment Funds. The investment fund is required to maintain reliable accounting records for 6 years, and the book of records cannot be destroyed, concealed, or altered prior to an audit by the Securities Commission. As required in most jurisdictions, an investment fund manager, an alternative investment fund manager, or an investment fund administrator should inform the commission if it intends to wind up, dissolve, or terminate the fund within 30 days. And the commission has the power to petition the court to wind up a company. An administration agreement can be terminated, but of course, the commission has to be notified when the investment fund administrator intends to terminate its administration agreement. And in this regard, he is required to appoint another fund administrator upon the expiration of his notice. He has to notify the commission of the appointment of any new investment fund administrator, and he also has to seek the commission's approval of whomever is the new investment fund administrator. The investment fund may dismiss its investment fund administrator for the following reasons: either it goes into liquidation or becomes bankrupt, or appoints a receiver over its assets. For good and sufficient reason, a written request is submitted by the investors with equity interest carrying 50% of voting equity interest outstanding, or any other good and sufficient reason. And then you could read the rest on the requirements under the act. If the investment fund fails to appoint a new fund administrator or refuses to accept any new subscription or process any redemption of shares, its license will be automatically suspended. So for those who are not familiar with the Investment Fund Act, just be aware that this is a new act. The old one was repealed and replaced, and which gives the Securities Commission a little bit more strength in terms of administering and supervising investment funds. The general duties of investment fund managers, and it's expected that investment fund manager will act honestly and fairly with due skill, care, and diligence in conducting its activities. And you know, the Securities Commission sent out the listing of the requirements for persons under these various positions. They have to take reasonable care to avoid conflicts of interest, comply with all regulatory requirements, and treat all investment fund investors fairly, and ensure that no investor in an investment obtains preferential treatment unless disclosed in the consultative documents. If the investment manager wants to delegate, of course, prior approval is required to delegate its functions to a third party. To do so, it has to qualify, has to be able to justify its entire delegation structure on objective reasons, ensure the delegate has sufficient resources to perform the function, and that the person who conducts the business of the delegate are fit and proper. And delegation of functions cannot prevent the supervision of the investment fund manager. So that means that whomever you delegate it to, that doesn't derelict you from you doing your duties. So that means that you have to make sure that the person you delegate it to has sufficient expertise and they're fit and proper to carry out the function. The investment fund manager must not delegate, and a delegate must not subdelegate portfolio management or risk management function to a custodian or a delegate of the custodian. The liability of an investment fund manager towards the investment fund it manages or towards its managers rests with the investment fund manager. So an application to the commission to delegate a function, you must be able to demonstrate that the delegate is qualified, capable of undertaking the function. The delegate was selected for appointment with all due care. The investment fund manager is in a position to effectively monitor the delegated activity. The investment fund manager is able at any time to give the delegate further instructions, and the investment manager is able at any time to revoke the delegation with immediate effect. So along with an investment fund manager, you must have a custodian. And the custodian is normally independent from the investment fund administrator, the investment fund manager, and the operator of the fund. And the custodians they have obligations to ensure that the sale, the issue, the repurchase, and the redemption and cancellation of equity interest of the investment fund is carried out, that the value of the equity interest of the investment fund are calculated, that the instructions of the investment fund manager are carried out. In transactions involving the sale of the investment fund assets, any consideration is remitted to the investment fund without delay. The custodian must hold the assets or the cash held for the investment fund separate and apart from the property of the custodian. Now in the new act, they also have the new category for the alternative investment fund manager. And this person could be the investment fund itself, an internal person, or could be an external person. And they also have to meet the requirements of the commission. So an AIFM should have an initial capital as prescribed by the commission and additional own funds to cover any liability in terms of risk or negligence or professional indemnity insurance. The commission will provide the status of the AIFM once the requirements of the act are satisfied. The AIFM must adopt sound administrative and accounting procedures, control and safeguard arrangements for electronic data processing, and have adequate internal control mechanism. So similar to the duties of an investment fund manager, the AIFM must at all times maintain general operating conditions They have to establish and maintain remuneration policies and practices for persons whose professional activities have a material impact on the risk profile of the AIFM. And AIFM should also establish and maintain policies and procedures relating to identifying, preventing, managing, and monitoring conflicts of interest. And of course, there's also a custodian, just as for the investment fund manager. The AIFM must ensure that a single AIFMD custodian is appointed for each investment fund that it manages. And an eligible AIFMD custodian may be a bank or trust company licensed under the Banks and Trust Companies Regulations Act, or a person registered under the SIA or any other institution that is subject to regulations or ongoing supervision, or an undertaking that's authorized by a competent authority of a member state. There are also reporting obligations to the Commission. An AIFM must report to the Commission not later than 1 month after the end of the reporting periods. The following every 6 months by an AIFM managing portfolio investment of funds whose assets are managed in total do not exceed the equivalent of 1 billion euros. And then I have listed the quarterly and annual reporting obligations. There are also a long list of ongoing obligations. And those ongoing obligations, just to point out just a few, the Commission may instruct an investment fund to be audited by an auditor or submit audited financial statements to the Commission. You have to give the Commission immediate written notice of any of the following if you're going to wind up or there's a dissolution of a regulated person or a subsidiary or holding company. If you're making a proposal of an arrangement with a creditor or creditors of the regulated person or the subsidiary or holding company. If you're bringing any action under the Act, you have to advise the Commission immediately. Where a regulated person becomes aware that a director, officer, or employee has been engaged in activities involving fraud or dishonesty, you have to advise the Commission. The failure of a bank or registered marketplace clearing facility or other entity with which a registered person has deposited or to which it has passed money belonging to investment fund or investors in investment fund, or where the regulated person is associated in any way in any business or financial activity with any person who has been convicted of an offense punishable by 1 year, or convicted of an offense punishable by 1 year or more in prison under foreign law or Bahamian law, or who has been barred. Then the next section I give you is on a professional fund. And these are designed for sophisticated investor. These are some of the products that you can have under the investment fund. And they could be offered by any banks or trust company that is licensed, any registered broker dealer or security investment dealer, an insurance company, an investment fund that is licensed, any natural person whose individual net worth or joint net worth is over $1 million, any natural person who has an individual income in excess of $200,000 or joint income with their spouse in excess of $300,000, or a trust with total assets of $5 million. Then the smart fund, which is another product that is offered to most of the foreign investors. You can have a pre-approved 7 template. That's the smart fund 1 through 7. And under each category, they give you the criteria. So a smart fund 1 is where the institution has a discretionary management agreement with its customers, and it'll set up an investment fund with such customers. A smart fund 2, there are no more than 10 investors in the fund. An investor will qualify to be an investor in a professional fund. And the majority of the investors have the power to appoint and remove operators of the investment fund. Then you have number 3, Smart Fund 3. This one, it can have no more than 15 investors. Your Smart Fund 4, no more than 5 investors. 5, no more than 5 investors who hold equity interest in the fund. Each investor in the fund is a person to whom a professional fund may be offered. You have 6, an investor, no more than 5, and of course 7, which is the super qualified investment fund. Single investor may be permitted, minimum investment of $500,000, maximum number of investors 50. Of course, you have the self-administered fund. Any questions? I know most Bahamians like their little small C-file funds for the investment, either in local investment or the international investments. Digital assets. Who knows about digital assets?
You mean like Bitcoin? Bitcoin and
Yes. So you know the Securities Commission recently passed their DARE legislation, Digital Assets and Registered Exchanges Act. And this is a new industry for the financial sector. And what the Bahamas is seeking to do is to try to get its foothold in this space. It's done a lot of comparative review of other jurisdictions who are in this space and try to make it competitive. So those who want to enter, businesses that want to enter into the fintech industry, this legislation is for them. So for us locally, the Sand Dollar is the digital version of the Bohemian dollar. And you know, I think the central bank recently said that there are more things to be done with regard to the Sand Dollar. So the last thing we want to talk about tonight is about when there are foreigners that you may meet who may invest in the Bahamas. They may want to purchase a home. But there may be opportunities for you to go in business with a foreigner. And you have to realize that there are some areas that are reserved exclusively for Bahamians. And then there are some where Bahamians can partner with foreigners. So joint ventures between Bahamian and foreigners, you know, you have to go through the National Investment Policy and the NEC, the National Economic Council. Because the National Economic Council is responsible for investment policy in the Bahamas. So for Bahamians, wholesale and retail operations are exclusively for Bahamians. Commission agencies involved in import and export trade, real estate, and domestic property management agency, domestic newspapers and magazine, advertising and public relation firms, commercial fishing, security services, domestic distribution of building supplies, construction companies, except those for special structure, personal cosmetic and beauty establishment, shallow water scale fishing, auto and appliance services, public transportation and landscaping are those areas that are being carved out just for Bahamians. The areas that they target for international investors are touristic resorts, upscale condos, information and data processing services, assembly industries, high-tech services, mariculture, captive insurance, pharmaceutical, banking and other financial services, ship repair and other services. Can someone share their views as to why you think these areas have been targeted for international investors?
They have a higher startup cost and a more difficult cost entry.
Yes, and they also have a high cost in terms of operations. If we do a comparison, and let's look at the banking and financial sector. If you were to do a comparison between local and international, what do you see? If you compare the commercial, in the domestic market, if you compare the international to the domestic banking institutions, what do you see? What differences do you see? Are they on the same level?
No.
No. Okay. If you look at ship repair and other services, I know we were in shipping a very, very long time ago. But if you look at shipping, do we have the expertise to be able to incorporate a company and actually repair ships? You're talking about the capital resources that are required.
No,
We
I
don't
mean,
have it.
you can't compare like a Grand Bahama shipyard and a Brownsville basin. So
No, you can't.
two different things, yeah.
Right. But of course, you do have the opportunity to form a joint venture with these. It can be done. And the Bahamas encourages joint ventures. Now, joint ventures doesn't mean that you as a Bahamian stay in the background or you just become the figurehead. It's both partners coming together and being visible. So permission for a joint venture is subject to initial review by the Bahamas Investment Authority. And then after that, you get the approval of the National Economic Council that is headed by the Prime Minister. The typical corporate vehicle for such a venture is a company that's established under the Companies Act. And with the Bohemian investor holding the majority of the shares, and normally is more than 60%. Of course, you need exchange control approval for non-resident who are shareholders. The business operations would be designated resident because it's 60% owned by Bohemian. And of course, it'll be subject to restrictions relating to borrowing and dealing in foreign currency and capital investments. You would need permission to open foreign currency accounts, and you also need permission from exchange control to repatriate any foreign currency from the Bahamas. The central bank will require evidence of the prior approval of the National Economic Council before granting approval for foreign ownership in a company, or the opening of foreign accounts, or the repatriation of funds from the Bahamas. The perimeters of such approval will often be guided by or dependent upon those perimeters and conditions that are set by the National Economic Council in granting it